We're hosting today's webinar to help our members and investors navigate the proposed federal vaccine and testing requirements for businesses. In September, the Biden administration issued executive orders that require employers with more than 100 employees to ensure that their workers are vaccinated or tested weekly, requires vaccinations for all federal workers and contractors that do business with the federal government, requires vaccinations for healthcare workers at Medicare and Medicaid participating hospitals and other healthcare settings, and calls on larger entertainment venues to require proof of vaccination or testing for entry. However, for today's webinar, our panel will focus solely on the executive order that requires all employers with more than 100 employees to ensure their workers are vaccinated or tested weekly. If you have questions for our panelists, we encourage you to place those in the chat or the Q&A, which either function is easier for you to access throughout the session, and those questions will be moderated. I'll now turn it over to Ryan Moon, our Public Policy Manager at Greater Des Moines Partnership, to introduce our panel and to moderate the discussion. Ryan.
Thank you, Meg, and thank you everyone for joining us for today's discussion. I'll give a brief introduction of our two panelists, and I'll turn it over to them for some opening remarks before we dive into some of the prepared questions we have. Our first panelist is Mary Funk. Mary Funk is a shareholder, an employment and labor attorney for Nyemaster Goode PC law firm here in Des Moines. Mary works with human resource professionals, counseling them on employment policies, hiring and firing, harassment and discrimination investigation, drug testing policies, non-compete agreements, and employee leave issues. Mary reviews and drafts corporate documents and employee handbooks and conducts employer training sessions to educate clients about the changing and ongoing employment issues. Thank you for joining us today, Mary. Our next panelist is Glenn Spencer. Glenn Spencer is a Senior Vice President of the Employment Policy Division at the U.S. Chamber of Commerce in Washington, D.C. In this role, he oversees the Chamber's work on immigration, retirement security, traditional labor relations, human trafficking, wage hour and worker safety issues, EEOC matters, and state labor and employment law. Before joining the Chamber in 2007, Glenn spent 6 years at the U.S. Department of Labor in the Office of Secretary, service as Deputy of Staff, and then Chief of Staff to Secretary of Labor, Elaine Chao. Thank you, Glenn, and thank you, Mary, for being here today and offering your expertise to our members and investors. Mary, I wanted to quickly just turn it over to you, just provide any opening remarks you would like to provide.
Sure. Thank you, Ryan, and thank you for the invitation to join your group today. Very happy to be here and provide you with some perspective from a legal and HR type viewpoint. So just some opening comments. I know that we've been all watching the news in earnest and have seen that there are at least 26 states and a whole variety of coalitions of attorneys general who have filed legal challenges to the OSHA, ETS, the emergency temporary standards, and we have suits pending in a variety of federal circuits. The Fifth Circuit is what we've been hearing most about. That covers the states of Mississippi, Louisiana, and Texas. So the Fifth Circuit has been the furthest along in the process, the legal process and challenges. This last Saturday, the Fifth Circuit issued an opinion, it's about 24 pages, really continuing its stay. It has not issued an injunction, but continued the stay until further review. So the court has really provided a roadmap, at least, of what the Fifth Circuit thinks are all the problems the constitutional issues in particular that come with the ETS. So I think that we may know more, might be by the end of tomorrow. The same challenges are pending in a variety of circuits across the country. So we have this judicial panel on multi-district litigation, and it's going to conduct a lottery of sorts. I don't know if it's a good lottery or a bad lottery. I guess that depends on your perspective of who gets the cases. But basically, it's going to draw out of a hat which circuit is going to hear the all these consolidated cases. So the Fifth Circuit could certainly be drawn. But if it's somewhere other than the Fifth Circuit, that circuit could then decide whether to vacate or continue the Fifth Circuit's stay. So there is still quite a bit that's up in the air. OSHA has recently stated that it's suspended its implementation and enforcement, but it's very confident in its ability to withstand these legal challenges. So my assessment really is that no matter what happens, and even if a stay is lifted soon, there's really not going to be a tolling effect of any of the dates by which we're going to need to be ready. So I think we're still going to have to be ready to go on December 5th, and with testing deadlines on January 5th. So I really don't think the wait and see approach is good. Certainly, I think employers need to be ready to go. So that's what we're going to talk about today, and give as much advice as we can about how the new ETS applies and what employers should be doing in that regard. So I'll stop talking now and let Glenn have a chance.
Thank you. And let me just second what Mary said about the advice for employers, because as she noted, there are some specific deadlines in the rule, December 4th and January 5th. And if employers wait to see what happens with the case until, say, December 2nd, and then suddenly discover the mandate is going to come into effect, that doesn't leave you enough lead time to start doing the things that you need to do to be in compliance. So it's certainly in everybody's best interest to start taking those steps now, so that if that comes to pass, you'll be ready. One of the things with the litigation is the states that don't like the rule and the AGs that don't like the rule have filed in particular circuits that they think will be amenable to their approach. What the unions have done is to file in different circuits where they think the more left of center, shall we say, circuits that they think might be favorably disposed towards the OSHA rule. That's where they filed suit. So we really don't know how that's going to play out until we start getting the results of the lottery. We see who wins that, wins, I guess, is a relative term here. See who wins the opportunity to take up the case, whether it ultimately goes to the Supreme Court. We just don't know those things yet. So there's a lot to play out in that space. And so for employers, your best advice is to make sure that you are ready. So when those deadlines come around, you'll be prepared. Now, we have asked OSHA directly. We had the Solicitor of Labor over here at the chamber last week, and I asked her directly, what happens to those compliance dates depending on the litigation? So if the rule is ultimately upheld, are you going to adjust those dates to account for the time? The fact is they don't know. She said, we don't know yet. We're aware of that. We're thinking about it. They don't know what they're going to do yet. So I would not count on those dates being moved. And I'll leave it there.
Well, thank you guys for providing that context. As you know, we will start diving into some prepared questions that we put together. A lot of questions that we're hearing from our members and our investors and our businesses. And a reminder to everyone, any questions that you come up with during this conversation, to please throw it into the chat or the Q&A function, and have the opportunity to ask Mary and Glenn here. But Glenn, I'll go ahead and ask you the first question, and then Mary, of course, feel free to jump in. How will this be enforced? What is potentially a company's penalty, if this all passes and this goes through? And what is OSHA looking like for penalties and things along those lines?
So operating from the premise that we assume the rule is upheld and it goes into effect, there's two ways that this gets enforced. Well, kind of three ways. One is OSHA comes and inspects your workplace and says, okay, show us the documentation that's required under the rule. Show us that your people have been vaccinated. If not, show us the testing results. That's one way. Second way would be someone files a complaint. And that could be somebody at the company, could be a customer, could be somebody else who files a complaint saying, we believe this company is not following the ETS. That triggers OSHA to come out and look. Third way would be an internal whistleblower complaint. Somebody who works at the company who has direct knowledge of whether or not they're following the rule calls OSHA and says, I'm a whistleblower and they're not following the rule. OSHA has been very clear that they are going to do everything they can to protect those whistleblowers. So they certainly see that as an avenue for enforcement, because the fact is OSHA doesn't have enough inspectors to do the job they have now, let alone follow up on this ETS. So I think they're going to be relying heavily on those whistleblowers to say, hey, my company is not complying. Now, if OSHA comes out and they find that you're not in compliance, there are some significant penalties that come with this. And the way the rule is written, I suspect those penalties will be per employee not per company. So they find that you're not following the rule, you have 200 employees, that could be 200 individual citations as opposed to just one citation for the company. Under current law, those penalties would be somewhere around 13,600 and change per violation. But I should note, in the reconciliation bill that is slowly grinding its way through Congress, those penalties go way up from 13,600 to somewhere around 70,000, potentially as high as 700,000 per violation. So those penalties could go up dramatically if that bill passes. So it's really in everybody's interest to be in compliance. Now, one of the things that the rule does also state is that in the case, one of the questions that was raised, well, what happens if we can't find enough tests out there because there's a shortage? What happens if the labs are backed up and we can't get test results back every 7 days? What are we supposed to do then? And OSHA answered that question by saying, if we come and inspect and we find that this has happened, we're going to look at your overall record of compliance. And if you're making a good faith effort to comply with this rule and you run into that situation where there's not enough tests or the labs are backed up, we're not going to enforce in that case. But that's sort of the rare outlier in their view. So I think if this does go into effect, they're pretty serious about enforcing it.
Mary, anything you would like to add to that?
No, I think that he covered the waterfront on that just fine. So that's great.
Perfect. Thank you, Glenn. So to sort of go along with some of those testing and OSHA coming into the workplace, how should employers, test the authenticity of test results or of a vaccine card? We've heard some examples. Someone may have a fake test or a fake vaccine card. Is there any good ways that an employer can check for those? And Mary, I'll turn it to you for that question.
Sure, thanks. I'll give it a good shot here. What we have seen from the FAQs as well as the ETS itself is that OSHA is not expecting employers to be fraud experts. Okay, so it's similar to I-9 processes, right? If there is a red flag that you look at, we've all seen the vaccine cards, right? If you can look at it and think, something's not quite right here, then probably OSHA would think that you should take a step to further investigate. But we're not going to be handwriting experts. What's important to understand, though, is that you have the obligation as an employer to make sure that your employees understand that they provide accurate and truthful information. We need to specifically advise our employees that they are to comply with our policies, which requires showing us a vaccine card or a proof of a test, and that they are doing so truthfully and under penalty of perjury if they're not truthful. So we're not supposed to be necessarily the police here, but we do need to make sure employees understand the magnitude of what they are agreeing to. And that's particularly true if, for example, an employee has lost or had their card stolen. One of the avenues for double checking that someone truly is vaccinated is allowing that employee the opportunity to sign an attestation. It's kind of a temporary hold, really, while they try and get their card, a duplicate card, but they specifically need to say that I verify that I am providing truthful information. We do need to keep track of those things, and we do need to keep records. We need to make a photocopy of the cards or the test. Those can be in paper format or they can be digital. If an employee took a screenshot, for example, and sent that electronically, that would suffice as well. Just as kind of an aside here, because I mentioned the I-9s, I think that probably if an HR person is keeping track of these documents, you'd kind of want to do it in the same way that you do the I-9 process and keeping those records separate in a separate folder. You do not want to have to go into every single person's personnel file to glean that information, because when OSHA comes knocking, they're not going to wait for you to get all your personnel files in order and pull out the right documents. So you need to have that information handy and ready to go. So I would maintain that in a separate file confidentially, of course, just like you do all your other HR records.
Mary makes some great points there. I did want to follow up on just a couple of things. So one is The rule states that OSHA is not expecting you to be responsible for fraudulent documents unless you as the employer are part of the fraud, right? If you're encouraging people to just show you bogus vaccination cards to get through the process of the rule, that would be a problem. But up short of that, if somebody hands you a fraudulent card, OSHA is not expecting you to be able to verify that. You're not responsible for the fraudulent documents. But they do expect you to hand out to your employees. In fact, it's required under the rule. There are 4 different documents you have to hand out to your employees, one of which is a document laying out what Mary, exactly what she just said, that handing in a fraudulent document is fraud. There are consequences to it, and they want employees to understand that. So you actually have to give them that document as part of the rule. In terms of the record keeping, Mary is right that you need, as an employer, you need to keep records of the cards, whether it's paper, digital, whatever she said. In addition, you need to keep records of the test results. So if you have an employee who is taking advantage of that testing option and getting tested once a week and providing you with the certification that it was a negative test, you need to keep a record of that every single time. So every 7 days, they're going to hand you a document that says they're negative. You need to keep that document every 7 days, and you'll have a stack of them over time, but you need to hang on to all of those. So when OSHA comes knocking, you can show them.
Perfect. Thank you too for that. So, as we're talking about that 100 employee threshold right now, and I have some questions regarding that. The first one, Mary, with that, do part-time employees count towards that 100 employee threshold?
Yes, they do. Part-time, seasonal, temporary, all those employees who are working for you and getting their paycheck from you are going to be counted no matter where they are sitting or where they are working. That's the short answer. Now, there are lots of FAQs on independent contractors and franchisees and temporary employees that we can cover as well. But the short answer really is probably, if you're in doubt, they're going to count.
And to continue that, Glenn, we keep hearing that 100 threshold, of course, but what about companies right now with less than 100? Is there anything going on right now that they should be paying attention to, or is it something, oh, this will only be 100, I don't have to worry about it, I only have 20? So what are your thoughts on that?
Let's say a couple of things. First, the 100 employee threshold is by company, not by location. So you might be thinking, great, I've got 5 facilities with only 20 people in them, I don't need to worry about this. No, that's not correct. You do. If your total head count, no matter where they are, adds up to 100, then you're covered. Second thing I would say is that just because you're below 100 now doesn't mean you don't need to pay attention to this, because at any point during the life of this ETS, and whenever it goes into effect at 6 months, if anytime during that 6-month window you go above 100, now you're covered, even though you didn't have 100 at the time the rule was first put into place. Now, let's say you sink below 100 before the rule expires, you're still covered. Once you hit 100, you're covered for the duration of the ETS, even if you fall below that. And the third thing I would say is that as part of the rulemaking process, OSHA now is in the comment period. Even though the rule is final, they're in the comment period to determine if they should make it a permanent rule after 6 months. Part of that comment period, they are considering whether to apply this to companies with fewer than 100 employees. So you may not be covered now, but OSHA is going to be asking themselves internally whether they ought to drop that coverage below 100. So it's something you still need to pay attention to.
And I would just say too, as a follow-up on that, that's one of the things that the Fifth Circuit talked about in its decision or its order on whether or not this is constitutional, is what's magic about 100, right? Shouldn't we be protecting workplaces with 98 employees or 76 employees? And so that number is something that I do think that Glenn's right, OSHA is going to be looking very carefully at. I had an employer ask me just the other day, I have 97 employees. What do you think I should do? And I kind of jokingly said, don't hire anybody else, right? I mean, you do need to be cognizant of that. The problem is that we have a lot of shortages with workers and we need workers. So, I say that with a little tongue in cheek, but definitely once you're in, like Glenn said.
And Glenn, I just want to clarify something you mentioned earlier. You said employees from all over. Does that mean if you have 20 employees here and 80 employees in Australia, for example, so global employees, does that count as well?
It does not. It only applies to US employees. But if you have 20 in Des Moines and 80 in Austin, Texas, that adds up to 100, you're covered.
Okay, thank you for that. So my next question, and Mary, I'll turn to you, is can employees mandate vaccines before January 4th? Can they do that now for their employees?
Sure, they absolutely can. An employer is allowed to do that now, whether there is an ETS or not. The caveat to that is if an employer is going to mandate, then the employer has to allow for the possibility of a religious or a medical exemption. So allowing someone to assert a sincerely held religious belief consistent with the with Title VII. Or a medical or disability type of accommodation with respect to the ADA. So once those exemptions are considered, then you have to go to the accommodation stage. And in this case, the accommodation is going to be weekly testing and masking. Before this goes into effect, an employer can choose if there are other alternative accommodations. So right now, if you had this kind of a policy in place, your accommodation could be that they don't have to weekly test. They could simply be segregated away from the rest of the population, whatever accommodations you think would mitigate their exposure to the other employees or customers. But once the ETS goes into effect, if you're a covered employer and you go with that option, then you will have to do the testing unless that person is working entirely remotely by themselves, like in a home office.
Thank you. And as we're talking about testing, because right now how it stands out is, you can either require the vaccines or require weekly testing. So with that, Glenn, who pays for the weekly testing? So if an employee decides that they'll go ahead and get tested weekly, who covers that?
So first off, let me clarify testing. The ETS essentially says thou shalt vaccinate all of your employees, but it gives employers an option. If employers want to provide a testing option, they can, but there's nothing in the rule that requires you to provide that testing option. That's just an option you might have. Now, if you decide that you're going to use that option because you've got people who don't want to get vaccinated and you don't want to lose those employees, and you decide, okay, we are going to allow for a testing option, under the rule, the employer does not have to pay for that testing or provide that testing. That is the responsibility of the employee to find the tests, take the tests, and pay for them. With one exception, well, two exceptions, and that is if you get that medical or religious exemption, because if you're providing a medical exemption, a religious exemption, now the employer is going to have to pay for that testing. So a little bit of nuance there, but just as it's stated in the rule, the employer is not responsible for providing or paying for testing.
Thank you. And coming with those testing, I don't know if you're any one of you able to tackle this one, is what test meets that standard?
I'll give it a shot.
Okay.
I'm not a doctor and I don't want to play one on TV, but the types of testing that the ETS talks about is diagnostic, not antibody tests. So you don't get to opt out of the testing if you can demonstrate that you already have had COVID, that you have the antibodies for it. So when we're talking about diagnostic testing, it's one of two different tests. One's the NAAT, nucleic acid application test, I believe. And then one is an antigen test. It's not the same as an antibody test. The antigen test is the only one that can be self-administered. So if you're, taking the swab and doing it yourself. But what you have to keep in mind here is that the ETS does not allow for unproctored self-administered tests or self-read tests. So if you're going to be doing that yourself, like you're driving through the Walgreens drive-through, the Walgreens pharmacist is going to have to watch you do that and proctor that test and then read that test. So there's another layer of authenticity to making sure that we're getting good test results. So Glenn, if I missed anything, you jump in.
No, I think you got that exactly right. The rule of thumb is it can't be a test where nobody's watching you do it. That's the bottom line here. OSHA wants to make this as leak-proof as possible. And in some ways, they want to make the testing as inconvenient as possible so that people just go and get vaccinated. That's really what they want to get out of this rule.
So to continue that discussion on testing, and Glenn, you sort of touched on this a little bit, is, you know, if an employee decides that they're going to obviously do the weekly testing, does the employer have to provide paid time off for their employee to get that testing?
The rule does not specify that you need to provide paid time off to do testing. Now, one of the wrinkles here is how wage and hour might look at that question of whether you need to provide time off, and how state law might look at that question of whether you need to provide paid time for people to go and get tested. We did ask the solicitor if she is talking to her own people inside the building, at the Francis Perkins building where the Department of Labor is headquartered, if she's talking to the wage hour folks about this issue so that employers don't get stuck in a situation where they didn't provide paid time off and suddenly wage hour finds it's a problem. She assures me that they are. So we assume that at least as far as DOL is concerned, OSHA and wage hour can talk to each other and figure out how to do that, and that it would not require people to provide paid time off. Now, state law may vary. In California, for example, I'm fairly certain that there you would have to provide paid time off for the testing. But as far as the ETS itself is concerned, it does not require you to give paid time off for testing.
And here in Iowa, we would follow the federal wage and hour rules on that. So if for some reason an employer decided to require that the testing could only happen in the middle of a shift, for example, that would be something that's probably compensatory time. But if they're required to get the testing on their own time, then they're not required to pay for that testing in Iowa.
Well, perfect, Mary. And to continue the Iowa discussion, I'll throw it right back to you. And Julie has a question similar to this in the chat. You know, given the differences between the federal role and Iowa state law, what guidance would you provide to the employers based here in Iowa?
Well, so Iowa Code Chapter 94 was enacted the end of October. It's a challenge. Okay, so we'll just start with that. It does not allow an employer very much leeway in terms of validating vaccine exemptions. And so if an employee says, I don't want to be vaccinated for any reason, or frankly, no reason, but says they're not going to be vaccinated, an employer in Iowa, pursuant to this state statute, is not allowed to delve into the rationale of why that person is not going to want to be vaccinated. So you can't delve into, are you sure you have a sincerely held religious belief? Or provide me with your medical provider's documentation to substantiate your request for an exemption. So under the Iowa statute, an employer is simply going to take the employee's word for it in that regard. So if you're trying to comply with the OSHA ETS, as well as Iowa Code Chapter 94, the option of test, or I should say vaccine or test, is probably the better option for you, as opposed to delving into the exemptions under federal law with respect to religion or disability or the medical exemption. So frankly, it's a bit of a conundrum, and we know we're not talking here about the other federal mandates, but the mandates for federal contractors and for CMS, for healthcare, particularly challenging with respect to compliance under the Iowa statute. So, this will be my plug for if you have specific questions on compliance with the Iowa law. Certainly, I'm happy to address those conversations or questions outside of this hour offline.
Thank you.
Let me follow up on that real quick. So other states have passed laws, for example, prohibiting a vaccine mandate in the workplace, or prohibiting an employer from requiring masks to be worn in the workplace. Those state laws are going to have to yield to OSHA at the end of the day. OSHA, assuming the ETS goes into effect, OSHA has very strong preemption here. So a state law that says you cannot mandate a vaccine in the workplace, that law is probably not going to stand if OSHA pushes the issue. Because the rule says, the ETS says that an employee who is not vaccinated must wear a mask in the workplace, a state law that says you can't require a mask in the workplace is also going to have to yield to OSHA ultimately. That's going to take a little while to work its way through the process. So in the meantime, it leaves employers in a little bit of a sticky situation where they've got two contradictory laws, knowing at the end of the day, the federal standard is going to prevail. But until that gets done in a court of law, it leaves you in a little bit of a bind as an employer.
Particularly when Iowa, as well as a number of other states, are part of the challenge lawsuits from the get-go. So yeah, in like our state OSHA folks, they're probably in an interesting quandary as well. So yeah, much yet to be determined. So stay tuned.
Right.
Thank you. And I'll open this up to either one of you. Can employers fire workers who don't comply? And if they are fired, does that worker then is eligible for unemployment? Well,
the short answer is yes, you can fire an employee who chooses not to get vaccinated in order to comply with the mandate. Your second part of the question is a little more interesting from the perspective of Iowa, because Iowa is one of, I think, 2 states that have amended their state UI law so that an employee who is fired for not getting vaccinated can in fact collect UI. In most states, that's not the case. You wouldn't be eligible, but Iowa, I think, is one of 2 where that actually is the case now, that you can collect UI for not getting vaccinated and being fired.
That's right. I don't know if we're one of 2, but we're definitely one under Iowa Code Chapter 94. That was part of the new legislation that went into effect the end of October. So anyone who is discharged will be able to file for unemployment benefits.
And speaking more through, is the employer liable if a worker experiences any symptoms from the vaccine?
Well, there are a couple pieces to that question, I think. Iowa has a safe harbor immunity type provision as long as employers are taking necessary steps to protect their workers and aren't negligently putting people in harm's way. There's a state statute that will provide limited immunity under certain circumstances. If you mean from like a workers' compensation perspective, my advice has been, well, first of all, I think the work comp carriers would say, how would we know where they contracted COVID? They could have easily had gotten it from, the grocery store as opposed to coming to work. But my advice has typically been in that situation to let the workers' comp carrier make those determinations. And so a lot of it depends, but in these later days of COVID with community spread, my understanding is, I don't do work comp work, but my understanding is that many work comp carriers are not covering COVID unless you can prove a direct exposure in the workplace.
Thank you. And I'm getting some questions in from our audience. So again, we encourage all attendees, if you have any questions maybe we haven't covered, or if you want some more follow-up, please use the chat or the Q&A feature, and we'll get those asked. One of the questions, will a vaccine or test requirements apply to remote workers or workers who work outside?
So you broke up just a little bit there, Ryan, but I think the question was how this applies to remote workers. And there's a couple of ways to look at this. So one is, if you have remote workers who are 100% remote, they are not coming into contact with coworkers, they are not coming into contact with customers, those individuals will not have to be vaccinated or tested because they are not coming into contact with anybody. But that means 100%. So they come into the office, one day a month to check the mail or, do a quick meeting. Now they're going to be covered and they're going to be subject to the vaccine mandate or testing. So 100% remote means 100% remote. There's a little wrinkle to that, though. Those remote workers do count towards your 100 employee threshold. Even though they don't need to comply with the mandate, they count towards your total. So there's one other exemption too for remote work. Well, it's not really remote workers, but if somebody is working out of doors full-time, that meaning they're not driving around in an automobile with 6 other people in it. They are outside, in the fresh air all the time. Those individuals could also be exempt from the vaccine or testing requirement mandates.
I've been asked a couple of questions about that outside of obviously the webinar here about outside workers, and because people would like to be counted as an outside worker. And so one of the questions I received was, well, what about our police officers, right? They're driving around in their own squad car. They're not in our brick and mortar, location. They're outside. I don't think that counts as being outside, because again, keeping in mind the purpose of the ETS is to get people vaccinated and get people who are interacting with the public vaccinated. And so when a police officer, they may spend a good portion of their day in their own car by themselves, but that's certainly not going to be the only thing they're doing. So they are going to be interacting with the public, going into people's homes or businesses or that sort of thing. So, when OSHA talks about working outside, they really do mean like almost all the time, unless you're going in to go to the bathroom. So I think that it's a very limited group of people to whom that will apply.
Thank you. Another question: if there's several small businesses that are that share a workspace, and do they all have to add up their employees each or equal 100? Thinking maybe of like a mall, for example.
Well, the short answer is no, you wouldn't. It's by company, not by location. So, you got 20 people working in a shopping mall, and the store next door has 20 people, and the one next door to that has 20 people, and so on down the line. Sure, that's going to add up to 100 at the location, but they're not your employees, right? You only employ the 20. So in that case, no.
Perfect. Thank you. Some questions coming in from Julie in Iowa. Do you see any issues placing employees on unpaid leave if they do not want to receive the vaccine or participate in testing masking process as an alternative to termination?
Well, I guess the question is, how long can you do that? Because at some point, if the ETS goes into effect, right, this is not something that is going to be around just for a couple of weeks or a couple of months. This is long term. So my sense is that most employers would not prefer to keep somebody on the roster who it does not have any expectation of coming back into the office. So a leave may be suitable for that person to get tested or show proof of vaccine, but it's a temporary type situation. It's not a long-term solution.
And another question from a participant, and please continue sending those our way, is, I touched on this a little bit, but what about employees in Iowa who claim to need a religious or ADA accommodation to be exempt from both vaccination and testing?
So, yeah, do you want to go?
Oh, no, go ahead.
So then you've got stacking exemptions and stacking accommodations. So you take each one in turn. So the first one is, do they have an exemption from the vaccine? Okay, so then you look at, well, if you do, and we've granted that exemption, then you're going to have to test and wear a mask. And so if one or both of those things, the employee also says, I have an exemption for, you have to think, okay, well, what is the possible accommodation that would be the alternative to testing and masking? The only one I can come up with is working from home. And that may or may not work for all employees. For some, may be a great solution. But for those people who are working on the assembly line, that's not going to work. So at some point, an employer always is looking at, can I accommodate this exemption? Or does it create an undue burden on the business? And so at that point, when it causes that undue burden because the person cannot do their work remotely, then that's the situation where an employee probably is not going to be able to remain employed.
Yeah, I think you've stumbled on the exact phrase, which is undue burden, meaning that just because somebody requests an accommodation doesn't mean you have to always give it at the end of the day. It may be the case that it's just not possible to get to an accommodation. I think that the main point for employers would be to go through the process to see if there's a way that you can find some accommodation that works. But if there's not, at the end of the day, you don't always have to provide an accommodation.
Thank you. And I'm seeing no other questions come in the chat, so I'm going to make one more ask out to our participants here. But before we conclude anything, I do at least want to give a couple minutes to Mary and Glenn here. Is there anything maybe we didn't talk about, or maybe any question that wasn't asked that you would like to address for our participants? And Mary, I can go ahead and start with you.
Well, one thing I guess we haven't touched on too much, I mean, maybe in the periphery here is, but what do you have to do, right? What do you have to do now? What should you be doing now? What do you have to provide to your employees? So right now, I suggest you need to know how many people in your workforce are vaccinated. So I would start that process if you don't already know. I know a lot of employers already have a pretty good ballpark, whether it was through an anonymous survey or you've already started down this road before the ETS came into being. But I think you need to start now and get your list going, get your documentation in line. You also need to be creating the policies. So you have to have a written policy and procedure. It has to talk about which option you're going to use. It has to say that retaliation will be prohibited. It has to provide for criminal penalties if people aren't being truthful. So your policy has to be very specific and have certain criteria. If you go to the website, the OSHA website, there are sample policies. One size does not fit all, though. So, when you look at these sample policies, just keep in mind that you're going to have to tailor them for your own individual situation. If you choose the option where you're going to look at the exemptions, right, you need to have those forms ready to go. And I would suggest that because those forms are based on Title VII and the ADA, I would have your employment counsel look at those forms to make sure that you are not asking too much or too little. And then you also need to supply to your employees the educational materials. You have to summarize the ETS requirements and provide a CDC document. Both of those documents are available for you literally to push print. But all of that information has to be provided. And so you need to think about a plan for how we're going to roll this out.
Thank you. And Glenn, before I give you a moment to offer any advice, one more question did come in through the chat, and I would like to put that question to you. And I know it's a little bit different than what we were originally focusing on today, but does the federal contractor mandate separate from the Biden one, or does it have the same 100-person threshold, or does that one apply to all employees?
Short answer there is it does not have the 100-employee threshold in that contractor mandate. So it's a little more restrictive, and the contractor mandate also doesn't have any testing option. It's you shall vaccinate employees, and that's that. So it's definitely a more restrictive regulation that applies to federal contractors. Should note also that federal contractor regulation, not likely to be undone by a court of law. There's been a little bit of litigation around that, but federal government has pretty broad discretion as to how contractors can be regulated. So if you're a contractor, I wouldn't anticipate getting out from under that one. In terms of sort of last thoughts here, I was going to go exactly where Mary went, which is what do employers need to be doing now? And she's exactly right. You need to start getting a plan in place. You need to start finding out who is vaccinated and who isn't, because it's not just that you want to have a general idea, you need to actually have the paper that shows it. So you need to start getting that stuff together now. The other thing you need to start thinking about is, and we didn't really touch on this at all, is come December 4th, there are a couple things that you need to start doing. One is to require employees who are not vaccinated to be wearing a mask in the workplace. So you need to make sure people know that that date is coming up and know in your head how you're going to deal with it for the masking requirement. Second thing you have to do on December 4th is start providing paid time off for employees to go and get their vaccination and to recover from the side effects of being vaccinated. So the PTO you need to give for the vaccination itself, that is in addition to any other PTO an employee has. So you can't make them use their existing leave balances to go and get vaccinated. And that's because the administration doesn't want to give any disincentive for someone to go and get their shot. So if someone would think, well, I'd lose 4 hours of leave they don't want that to happen. So you need to provide extra leave on top of anything else for people to go and get their shot. So you need to know how you're going to handle that. And then if someone experiences an adverse side effect, and certainly there are people who have had that from the shots, they've been unable to go to work for a day or two while they recover, that again is something that you have to offer leave for. Now that leave can be taken from their existing balances. So if they have sick leave or PTO, whatever it is, they can use that to cover those 1 or 2 days that they might need to recover. Anything beyond 2 days, OSHA said that's on the employee. You're not responsible for anything beyond that 2-day period if someone does need a little bit of time to recover. So a couple things you need to think about for December 4th. So start doing what you need to do to get ready. And Mary is exactly right in terms of the documents that you have to hand out. There are actually 4 of them. They're available on the OSHA website, relatively easy to find. Just click them, as she said, click, print, that you can hand out to people. The last thing I'd mention is employers really need to have buttoned down what they're going to do with religious exemption requests, because they will be coming. We've had at least one large employer tell us that they've gotten a couple thousand religious exemption requests already, and they are outnumbering medical requests by 20 to 1. So you may get some medical exemption requests, but you're definitely going to get religious exemption requests. So you just really need to know how you're going to handle that and what you're going to do with them, especially because you've got a unique law in Iowa that tells you one way you might have to do it as opposed to people in other states. So you really need to have that buttoned down.
Thank you guys for those closing comments. And I'll turn to our members and investors on the call today. This is obviously very fluid right now. There's a lot of information, and we're all trying to digest it and understand it. So if you have any questions that maybe you think of later, or as something new comes up, feel free to reach out to myself, and I may have to send an email to Mary or Glenn real quick to get a really good answer. But my email, I'll put in the chat, is rmoon@dsmpartnership.com, and we're happy to help answer any questions that you may have. But again, thank you to Mary and Glenn for using your time today to talk to our members and investors, and just to really help provide some context on obviously a very new and complex thing that's happening. So thank you both, and thank you everyone for joining us today.